This is LXBN TV, and I'm Colin O'Keefe. A Washington federal district court recently dismissed class action claims against Amazon, alleging the company used cookies to track consumers' personal data without permission and override the user's personal browser settings. To explain the lessons from the case, we bring in Gerald Ferguson, national co-leader of Baker Hostetler's privacy, security, and social media team, and author on the firm's Data Privacy Monitor. Jerry, starting with the basics, what was Amazon accused of doing, and how did they come out ahead in this litigation?
Well, Colin, you've summarized it pretty well. The central complaint here is that Amazon was placing cookies on users' browsers and doing it in a way that defeated settings that users had put into the browser to not accept cookies. And the allegation was that this was actually a violation of a federal anti-hacking statute, the Computer Fraud and Abuse Act, because a security measure was being defeated so that Amazon could place bits of code on those users' browsers and track what those users were doing. That was the key allegation. The problem with the claim that the plaintiffs were asserting is that the Computer Fraud and Abuse Act has a damages threshold. You've got to show that you were damaged in the amount of at least $5,000 in order to have a claim. The plaintiffs tried to satisfy that by saying, we know our personal data is valuable. That's why Amazon's collecting it. They're taking all that usage data and finding lots of ways to make money out of it. And the judge came back and said, yeah, but plaintiffs, you didn't show us that you could have made money off of it. You didn't show that you had the opportunity to sell your usage data, so we're not buying that claim. There was actually also a claim under the Washington State Consumer Protection Act that wasn't dismissed yet, although from the opinion it's probably going to be soon. And essentially the reason why that wasn't dismissed is that the court found that you didn't actually have to prove monetary damages under the Washington State Consumer Protection Statute, but instead the judge saw another hurdle, which is that the fact that Amazon, in its terms of use, says we're going to use cookies, and if you want to use our site, then you've got to consent to the use of cookies. The judge found it likely that the fact that people kept using the site with that warning in place was in fact consent, and therefore there was no claim. There will be further briefing on that, but the judge has signaled where he's likely to go on that.
I see. And what's the biggest lesson then that website owners can learn from a case like this?
Well, the trend in these privacy class actions is that the defendants usually win, and it's usually on these issues such as the failure to properly allege a recognized form of damage, or the failure, something else like the consent defense that was raised here. I do think as a website operator, this decision has to give you pause, because the fact that the damages were considered to be sufficiently alleged, and so it becomes a consent issue. I think as a website operator, you've got to look at how you are currently getting consent to cookies, and you have to look at it in terms of what's happening in the broader world right now. I mean, in Europe, the privacy authorities are requiring much greater consent at how cookies are used. In certain circumstances, they're looking for pop-up windows. They're looking for detailed disclosures, which are not common in the United States right now. The FTC also has issued a white paper in which the basic message is we're not happy with how cookies are being disclosed to users. We're not convinced that users have enough control over their cookies. So we want industry to try and solve this problem with the implied threat that if you don't solve it, we, the FTC, are going to solve it. So I think the fact that this Amazon decision puts this consent issue front and center means that every website should be looking at how they're disclosing the cookies they have, whether they can disclose what they're doing better, and whether there's steps, non-intrusive steps, that they could be taking to better argue that they have consumer consent to their use of cookies.
I see. Well, having done a number of these interviews on similar incidents, it seems that the only way for users to come out ahead in litigation where companies invaded their privacy without permission is to show quantifiable damage for that invasion. And then you suggested even that the plaintiffs, had they shown that they could have made money off that data, then they possibly could have came out ahead in this case. But what about those people who just don't want websites and companies tracking their behavior without permission? Will a time come when that will be enough of a reason for them to come out ahead in litigation in cases like this?
Well, it's an excellent question, and I think the Amazon decision actually points to a possible answer there. There is an emerging trend right now. We're at the very early stage of personal data management and control. The World Economic Forum has identified personal data as the asset class of the 21st century. And there are a number of companies that now are developing personal data vaults that allows a user to take, an individual to take control of their own web browsing practices, do it in a password protected, encrypted environment that they have access to, and that they can share when they want to share and not share when they don't want to share it. And so the emergence of these personal data vaults creates the possibility that individual users, you and me, will actually be able to sell our usage data to marketers if we choose to, or not sell it if we choose not to. And if the existence of such data vaults had been widespread at the time of the Amazon decision, under the logic of that decision, there might have been a different result, because the plaintiffs could have said, we have the opportunity to sell our personal usage data to marketers. We choose not to do it, but there is a quantifiable value in that data based on what we could have sold it for, and that's over the 5,000 threshold of the Computer Fraud and Abuse Act.
Definitely, and that's going to be interesting to watch, to see what impact those people, to see if those types of companies have an impact on even those people who don't use them, because if they had the potential to sell that information, even if they didn't already do so, that once there's a firm value on that, I think we're going to start to see interesting developments come out of that.
I agree with you.
Well, once again, that was Gerald Ferguson of Baker Hostetler. For more of his insight, be sure to visit dataprimacymonitor.com. It's an excellent publication, many great authors on that, one of the best privacy ones on our network. Be sure to visit that. And of course, for more LXBN TV interviews, visit us at lxbn.lexblog.com. Thanks, Jerry.
Thanks, Colin.